Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and I am excited to have started this show. On today's show, we will discuss certain excerpts of a judgment wherein Honorable Justice Sanjay Kishan Kaul of the Honorable Supreme Court of India wrote a postscript highlighting the tedious and the time-consuming nature of proceedings that transpires in our courts. The name of the case is Ajit Mohan and others versus Legislative Assembly, National Capital Territory of Delhi and others. However, today we will not discuss the facts and the law discussed in this case. Rather, our focus will be on the postscript authored by Honorable Justice Sanjay Kishan Kaul. The postscript began by explaining the difficulty faced by everyone, including the judiciary, since COVID 19 came into foray. Thereafter, it was mentioned that the hearing of the instant case consumed 26 hours and that there were voluminous pleadings and written record that the court had to go through to decide the dispute. According to the court, if precious time would be consumed like this in cases, then it would be very difficult to deal with the post COVID period wherein there is a reasonable likelihood of seeing a surge in the number of court cases pending adjudication. The court also suggested the way forward and stated that the advocates or the counsels must have clarity on their arguments before addressing the court, accompanied by a brief synopsis to be submitted by all the concerned parties. It was opined that the Indian courts are one of a kind wherein they allow the advocates to argue for such lengthy periods, and who gets to argue for the longest time is becoming the norm. International best practices and other guiding principles in this regard were also discussed. Some of the pertinent ones are: A. Article 6 of the European Convention on Human Rights provides that trials must be completed within a reasonable time. B. The need of the hour to write clear and short judgments and the Wren and Martin principles of précis writing must be adopted. Wren and Martin is a very famous book that many of us would have studied for learning English grammar in our childhood. It seems that the court and Honorable Justice Sanjay Kishan Kaul also adore Wren and Martin. An old adage given by Viscount Falkland in 1641 was also quoted, stating that if it is not necessary to refer to a previous decision of the court, it is necessary not to refer to it. Similarly, if it is not necessary to include a previous decision in the bundle of authorities, it is necessary to exclude it. That approach will be rigidly enforced. It was also observed that often junior advocates are asked to prepare spiral bindings to submit voluminous compendiums of judgments to the court. According to the court, some matters are complex that require such lengthy pleadings and arguments, but not all cases are like that. The court also underscored its melancholic desire to have case management hearings that could reduce judicial time, but due to large volume of cases, it is not getting followed. As of 1st of May 2021, 67,898 cases are pending before the Honorable Supreme Court of India, and the court acknowledged that due to the time spent on routine matters, larger legal questions are not being settled. Concern was also raised by the court in relation to prolonged interim proceedings like bail matters, wherein hours are consumed for a single matter at multiple levels. And this is true even in civil proceedings, where only a short order is passed to protect the interest of the parties after hearing them for hours. And due to all this, the final hearings get conducted only to spark a new set of proceedings. The court concluded by observing that the purpose of the postscript is to start an earnest discussion among the legal fraternity regarding the ways and means that could be adopted to save the precious time of our honorable courts and to write judgments in a manner that is understandable to common man. The last sentence of the postscript seems quite relevant. It is stated that, after all, it is for the common man that the judicial system exists. That was all about the postscript by the Supreme Court. So, what are my concluding remarks? I feel that the last sentence of the postscript is quite pertinent, as there could be no second thoughts that judicial system exists for the common man. But why is the common man having so much difficulty in accessing the avenues of justice? The problems highlighted in the postscript are some of the most common issues that have plagued our judicial system. Endless filing of documents compounded by endless hearings of stupendous durations is a big culprit in this regard. I think that the courts as an institution have developed means and infrastructure through which filing and hearing of cases post COVID have become much easier. Online filing and hearing of cases is no less than a revolution, but this needs to be coupled by intelligent and succinct pleadings so that as less of the judicial time as possible gets consumed. The beauty of law lies in the fact that no matter how complex a matter is, by usage of legal language, the same could be condensed in few words. Many of you must have heard the Hindi adage, Gagar mein sagar. I think that needs to be incorporated in letter and spirit within the legal ethos of this country. Hence, I hope you enjoyed listening to this show. Thank you for listening. Please do not forget to like and subscribe us. And if you have any comments, please make them in the comments section. See you next time. Till then, stay tuned.